Hello, I'm Rex Barton. I'm a police management consultant with the Municipal Technical Advisory Service at the University of Tennessee. Today, we're going to talk about the public's right to protest and what cities can and cannot do relative to those protests. It's important to tell you on the front end, do not use this talk as legal advice. It's based on research on legal issues and case law, but I'm not an attorney. I'm an old cop. Please consult with your city attorney before you take any action relating to protest, freedom of speech, and freedom to assemble. Any discussion about freedom of speech and the right to assemble involves constitutional rights. I want to stop a minute and remind you, when I was a police officer many years ago, I had to take an oath of office. The opening line to that oath of office was, "I swear to uphold the Constitution of the United States of America." If you're a police officer or if you're an elected official, you've taken a similar oath with similar language. I take that pretty seriously, and you must take it seriously too. When you discuss constitutional rights, we have to remember there's the Bill of Rights, the first 10 amendments to the Constitution. And the first of those, the First Amendment, is one that's talked about more than any other. It guarantees us a right to freedom of religion, freedom of speech, freedom of press, and a freedom to assemble and to petition the government to address citizen complaints. The actual language of that part is this: the right of the people peaceably to assemble and to petition the government for a redress of grievances. Notice I didn't say anything about vandalism or arson, breaking into buildings, looting, or stealing. The right of the people peaceably to assemble. Let's talk more specifically about freedom of speech for a moment. The courts have given sweeping protection to all manner of speech. All manner of speech. It doesn't matter if you don't like the speech. It doesn't matter if it's loathsome. It doesn't matter if it curdles your blood. It makes you so mad you can't see straight. That speech is protected the same as speech that's popular. Governments in general, and law enforcement in particular, are oftentimes the subject of assembly and protest and free speech. And oftentimes the content of that speech isn't very nice about us. It's protected, period. This applies even if the speech is offensive to the majority of people in your community. The majority does not rule here. The speech is generally protected. There are a very few exceptions, and let's talk about two of those. One is incitement. When someone tries to incite a crowd to violence, imploring people to take up arms against the police department or to break into the courthouse and set it on fire. That speech is not protected, and you can shut that down. But you can't limit speech on the front end because a speaker might try to incite violence, because the content of their speech is so terrible and so vile that it will cause people to want to be violent. Fighting words are another one. Fighting words are speech that's expected to incite an immediate breach of the peace, something that makes someone so mad they're going to reply in a violent manner. But that's generally directed toward an individual, not a group, and it's rarely the case when you're at the scene of a protest. Someone described it to me one time as fighting words are when someone gets in your face and says something really bad about your mama. That's not really fighting words unless the person reaches that point of threatening violence against your mother. That's rarely going to be the case when you're in a group setting at a protest. So let's not try to use that one unnecessarily. Cities have the authority, a limited authority, to regulate assembly on public property. Public property primarily being the roads, the sidewalks, parks, because those facilities are there for a very specific purpose. Obviously, we drive on the roadway. Obviously, pedestrians walk up and down the sidewalk, and there's a very real need oftentimes to protect those folks, to ensure the safety of people driving on the road, to ensure the safety of people on the sidewalk. So you can pass an ordinance regulating those assemblies, parades, marches, but you have to do that by ordinance, and you have to do that on the front end before the event takes place. The permit process has to be content neutral. You can't allow someone to assemble or someone to have a parade when they're going to say one thing and not let someone assemble or have a parade when they do something else. So if people want to march around your courthouse or your city hall complaining about government, you can't say no when you're going to let the Christmas parade drive around the courthouse or city hall or the high school homecoming parade. That also, your permit process cannot provide broad discretion to one person or, more, or two people to approve or disapprove permits. The ordinance itself has to define clear and reasonable grounds for not approving a permit. You have to do that to ensure that an individual doesn't turn down one group wanting to protest and yet give a permit to another group because they like the content better of one than they do the other. When you have a permit ordinance, you should exempt small groups that don't implicate public safety, traffic safety, or the use of the public right-of-way. A great example of that is in Knoxville for many, many years. A group of 2 or 3 nuns every Monday or Tuesday came downtown and protested in front of the federal building. They did not impede traffic on the roadway. They did not impede traffic on the sidewalk, so there's no need for a permit. You also cannot outlaw spontaneous demonstrations, those things that happen that aren't pre-planned. Maybe a court case goes a certain way and people get really mad and they want to gather outside the courthouse and complain. To try to make them disperse because they don't have a permit would be illegal. The court allows for spontaneous demonstrations. Also, you can restrict amplification to some extent. Amplification being the megaphone, the bullhorn, the speaker system, but it has to be defined in your ordinance how that will be regulated. The hours of operation, the places they can be used, and how loud they can be. But if you're going to regulate how loud they can be, you're going to have to define the decibel level, and you're going to have a way to measure the decibel level. You can't just simply walk up and say, I think it's too loud, so shut it down. The reasonableness of this is best stated this way. You don't have to allow someone to use a loud megaphone in a residential neighborhood at 2:30 in the morning when people are trying to sleep. Thank you for taking part in this discussion, and I hope it's been helpful for you. I want to take just a moment to thank the MTAS legal consultants Melissa Ashburn, Stephanie O'Hara, and Alicia Hodge, as well as my colleague and other police management consultant David Moore for helping prepare this presentation.